It's really my duty and really my honor now to introduce the chair of the next panel, the moderator, who's actually my predecessor as the AAAS co-chair for NCLS, Dawnie Steadman. Where are you, Dawnie? There we are. Dawnie is a forensic anthropologist. She's the director of the Forensic Anthropology Center at the University of Tennessee, Knoxville. But in addition to her forensic anthropology research, which centers around sort of archaeological investigations of historic burial sites, she's also had a very distinguished and long career serving on human rights investigations on numerous continents, actually. So a career of public service in service to human rights as well as her academic career. So Dawnie, please take it away.
Peter, you're all set.
Yeah. Yeah.
So good morning, everybody. Thank you so much for being here so early. So we all know the names: Fred Zane, Joyce Gilchrist, Annie Dukin, David Kofod, and even Sandra Anderson, who conducted fraud with forensic evidence, be it dry labbing or intentional manipulation of evidence. But we also know that these individuals could not have been so successful in their activities if there were substantive SOPs in place and oversight of lab activities, prosecutors who were willing to contribute to post-conflict reviews, and judges who can see the forest, the trees, and the entire landscape of the system and be willing to serve on boards and panels to improve the system. Today, we're fortunate to hear from three people who are at the forefront of these efforts, and it's my pleasure to introduce each of them now. Dr. Peter Stout is the CEO and president of the Houston Forensic Science Center. He initially joined the agency in 2015 as its chief operating officer and vice president. He has more than 20 years of experience in forensic science and forensic toxicology. Prior to joining the HFSC, Dr. Stout worked as a senior research forensic scientist and director of operations at the Center for Forensic Sciences at RTI International. Dr. Stout has also served as president of the Society of Forensic Toxicologists, my favorite acronym ever, SOFT. He is currently the president of the Texas Association of Crime Lab Directors. Dr. Stout has a doctorate in toxicology from the University of Colorado Health Sciences Center in Denver. Dr. Stout also served as an officer in the U.S. Navy Medical Service Corps. And he is a self-professed science geek, which is my favorite title of his. Cynthia Garza is a Special Fields Bureau Chief. I'm going to get this right, Cynthia. Special Fields Bureau Chief, there I did it, of the Dallas County Conviction Integrity Unit. She obtained her undergraduate degree in both psychology and sociology from Southern Methodist University and graduated from Southern Methodist University Steadman School of Law. Ms. Garza practiced trial and appellate criminal defense at the Dallas law firm of Sorrells, Udashin, and Anton. My apologies to all of those partners if I butchered their names. Before joining the Dallas County District Attorney's Office's Appellate Division in 2008. She joined the Conviction Integrity Unit in January 2010 and has been involved in a significant percentage of the unit's exonerations. Ms. Garza was named a Rising Star in 2008 and 2009 by Texas Super Lawyers magazine and was awarded the Latina Government Leader by the Greater Dallas Hispanic Chamber of Commerce in 2014. She has served on the board of directors for various bar associations, including the Dallas Hispanic Bar Association and Dallas Association of Young Lawyers. She has also co-chaired committees with the Dallas Bar Association. In addition to heading the Dallas Conviction Integrity Unit, Ms. Garza trains fellow prosecutors, defense attorneys, law enforcement agencies, and judges on actual innocence and wrongful convictions. Finally, we're fortunate to have here Judge Barbara Parker Hervey, who was elected to the Texas Court of Criminal Appeals in November of 2000. A native of New Jersey, Judge Hervey earned a Bachelor of Arts degree in 1975 from the University of North Carolina, Greensboro, and her JD in 1979 from St. Mary's University School of Law, where she is currently an adjunct professor and a past recipient of the Distinguished Alumni Award. Prior to becoming a judge, Judge Hervey was in private practice for 5 years with the law office of M.M. Pena Jr. of San Antonio. She was also an assistant criminal defense district attorney in the appellate section of the Bexar County District Attorney's Office for 16 years. Judge Hervey has been an author and speaker of over 150 lectures and legal seminars, served on the governor's ad hoc committee to rewrite the Texas Code of Criminal Procedure, supervised continuing legal education for attorneys in the DA's office, served as a faculty member of the National District College of District Attorneys, and co-authored the Appellate Prosecutor Professional Responsibility on Appeal. Judge Hervey is currently a member of the State Bar of Texas, the Texas Bar Foundation, and the American Law Institute. She is the chair of the Grants Committee and the Criminal Justice Integrity Unit, and is a member of the Rules Committee for the Court of Criminal Appeals. Judge Hervey has served as a member of the Governor's Criminal Justice Advisory Council and the Tim Cole Advisory Panel. She has received the Appellate Advocacy Award from Region 6, Association of Government Attorneys in Capital Litigation. She has also received a Certificate of Appreciation from the San Antonio Police Officers Association in recognition of her work on Jonathan Moore v. State of Texas, tried for the capital murder of SAPD officer Fabian Dominguez. You can see we have a very distinguished panel, and I would like you to welcome them today. Peter, let's start with you.
Good morning, y'all. Get introductions like that, just reminds you how old you are. I just cut the gray hairs off, that's all I do. Let's see, there's a button. So yeah, my goal here is really to set these two up about stuff in Texas, because I talk with groups all over the world that are shocked about, yeah, the word progressive and criminal justice in Texas. But there's a lot of stuff that's happened in Texas. And I argue, actually, a lot of it is, well, in Texas, a lot of it is because of Houston, but I also argue that fundamentally, Houston has been an inflection point in the discussion around forensic sciences, period. Houston altered how the world views forensics, because this article came out 20 years ago. Adam Liptak, and this was the original headline on it. It's changed as they've republished this, but the worst crime lab in the country. Hi, that's us. I tell staff, never ignore this, never try and explain it away, never forget this. The moment we forget it, we will be right back there. Now, I've got 15 minutes here. I can kill the rest of the day if y'all let me. What I will say is there's a special edition on forensic sciences coming out in Proceedings of the National Academy of Sciences. Should publish soon. Tom Albright and Jennifer Mnuchin are the editors on that. They were silly enough to give me 9,000 words in there, so there is an article from me, way too long, that covers kind of a lot of the similar stuff in a lot more detail within it. So what I'm trying here today is to get everybody at least framed up with the 20 years from this disastrous circumstance in Houston until now has grown up a framework around forensics that, as flattering as it is for all the stuff that we get to do in Houston, I can't do what I do without all of the rest of this stuff. And I say in lots of places, all of the sciencey stuff, sorry science nerds, it's like this much of the problem. It's all the stuff around the test tubes that is the enormous challenge for us. So I point to this article. This one was in the Atlantic about a year ago. Barbara Haggerty is a marvelous journalist, spent a lot of time interviewing with her, and this is how the article turns out. About 6 vignettes of forensic science gone horribly, horribly, horribly wrong, and then I show up in the last paragraph. Crazy piece of people down in Houston have it all figured out, go do what they do. Thank you very much. It's very flattering, however, way oversimplified. So, no, I'm not going to call up a journalist and tell him please change that headline, but again, tremendously oversimplified. What this narrative is missing is all of the other stuff that has to be there for us to even be able to exist and function. So it is Texas Forensic Science Commission. And John Morgan Beck here has been working on the board of the boards, trying to organize commissions and advisory boards around the country for better communication between those, because Texas often gets pointed at as the commission that works. Yes, it exists. explicitly because of how bad Houston was. 2005, the legislation that formed it, in the legislation it cites, this is in response to failures in Houston. But I can't do what I do without the commission. I can't do what I do without Houston Police Department. They are a billion-dollar organization. I'm 30 million. They could crush me in a heartbeat if they chose to. City of Houston, I can't do this without the City of Houston being on board with this. The Harris County District Attorney. Then we get to some of the framework that has built up. The Michael Morton Act, and I think, Cynthia, you're going to talk more about that in detail, I think fundamentally changes the landscape in Texas. Texas, I've dealt with forensics in a lot of different states. Texas is different, and it's not just because it's Texas. But this legal framework there makes a big difference. The existence and high-functioning public defender's office in Harris County, the existence of prosecution integrity units, and Cynthia's a big part of those. Prosecution integrity units started in Texas. Huge difference in how things function because of that. There is a Texas Bar Association decision called the Schultz decision that a prosecutor was actually had a finding against him. I think he was disbarred, wasn't he?
He had a probated sentence.
Had a probated sentence, but had a significant finding against him for not disclosing things. So it changes how prosecutors view all of this stuff. And then I got 200 really smart nerds in the lab who actually do all the work, and I just get to talk about it. But other thing I will leave you with before I turn it over to them is never, ever, ever, even for a moment, think that we don't have mountains of work yet to do. This is, here just recently, you are gonna hear more noise about me because we are in an election cycle for the mayor and for the district attorney. I am a convenient whipping post for all kinds of problems in the criminal justice system. But no, this pressure to just give me the answer right now is immense. So all of this stuff we're talking about, of the sciencey stuff, you cannot discount this kind of pressure. And even with all the structures I have, I still have this. So imagine what this means for laboratories that don't have all of this. So with that, Cynthia, you're up next, right?
I'll sit here even though my feet don't quite touch the ground. Just the tips. So yes, thank you, Dr. Stout, for that great kind of framework that you put together. In preparation for this talk, I started thinking, okay, when did this all start? When did we start having these types of conversations, amongst legal practitioners that have sparked, seminars such as this? And I go back to around 2007. So in 2007, July of 2007, the Conviction Integrity Unit, which I lead now, was established in Dallas. And it was a novel concept at the time. The district attorney at that time in Dallas thought, I think that there's probably wrongfully convicted people in prison, people who are innocent, who did not commit the crime that they were convicted of. And isn't it the job of the district attorney's office, who put them there in the first place, to go back and reinvestigate to see whether or not claims of innocence are truly meritorious, right? Are they real? So, of course, at that time he got pushed back from a lot of people saying, how is that the job of the district attorney's office? But he went ahead and he created the Conviction Integrity Unit in 2007, like I said. And after the creation of the unit, what we started looking at that time was a list of cases where a person had requested post-conviction DNA testing under the statute in Texas that was passed in 2001. And that person had petitioned for post-conviction DNA testing and they were denied. So the list was probably around 400, 450 cases. And that's what the unit started looking at. And out of the cases that started, undergoing forensic DNA testing, we got exonerations. And so the concept was no longer something that was nebulous or in the DA's mind. It was being shown by these exonerations that were coming down because of DNA testing showing that this person did not commit the crime that they were convicted of. Shortly after that, and Judge Hervey can talk a little bit more about the establishment of the Conviction Integrity Committee that she headed up after this started happening in Dallas. But, you know, going from there, in 2009, the NAS report was issued. And still, people were kind of thinking about it still, not really knowing what to do about it, I think probably on the legal side of things. If you think, you know, about how the intersection of law and science works, right? So you have the scientists, and then you have the lawyers, and lawyers will often joke and say, we went to law school because we don't like science or we don't like math, right? And so a lot of times, you know, we kind of, you know, we rely on the scientists as the expert, right, to teach us about whatever discipline we're trying to present in our case. So we don't try to become the expert, at least that's, you know, the thought. You don't try to become the expert. There's no way you can become the expert, but you should at least become knowledgeable about the discipline that you are presenting in court. And the way that I always think about it is the science is only as good as the end user, right? The end user in the legal side is, you know, the prosecutors or the defense attorneys, whomever presents it to the fact finder. And we have to make sure that we adequately explain it so that the fact finder could come to a conclusion that's just. And those are the kinds of conversations that were, I think, starting to happen at that time. But it wasn't until probably it was 2013 when the Texas legislature decided to pass 11073, which is in our Texas Code of Criminal Procedure. And 11073 deals with forensic sciences in habeas post-conviction contexts. And that really was established because the law there wasn't a mechanism to challenge forensic science, the evolution of forensic science in a post-conviction setting with regard to the changes of the science since the time it was originally presented at the time of the case, when it was originally presented at that time. So let's just think back. For example, in a conviction back in the 1980s or something like that didn't have forensic DNA testing at that time. That was typically presented in these cases was, you know, hair microscopy or serology or something like that, but it wasn't forensic DNA testing. And so you're looking at that, and Judge Hervey will talk a little bit more about the intricacies of 11073 and how the court interprets that. But that is now, that law, 11073, is termed the junk science law in Texas. So if you ever hear that, that's what they're referring to. So that was passed in 2013. In 2014, the Michael Morton Act was passed, which was referenced by Dr. Stout. And that really sparked the change in discovery in Texas. It became like an open file policy where, you know, the state had to show the defense all of our cards. It's not reciprocal discovery. It's not like in civil cases where you have reciprocal discovery. In a criminal case in Texas, the state has to basically show all the police reports, all the lab reports, not just the lab reports, but we have to show basically a litigation packet. If something went wrong during the time of the testing, there has to be a disclosure, and the disclosure is usually in the litigation packet, and all that has to be laid out. If we, as the state, do not do that, that puts our case in jeopardy. So if you get a conviction, your conviction can get overturned. So everybody in Texas started, our ears perked up going, okay, on the prosecution side especially, what do we need to do? At that time in 2000, so it was January 1st of 2014 when that law came into effect. Normally, laws come into effect in September 1st. This law came into effect January 1st of 2014. And that New Year's Day of 2014 marked the change in the way that prosecutors try cases and the way criminal cases are tried, just period, in the state of Texas. Other states have tried to emulate this law, and because they started seeing, like Dr. Stout said, a lot of people were surprised at what was going on in Texas. Wow, Texas has an open file policy now. What's going on over there? So states started looking to see how things were going in Texas. Meanwhile, all the prosecutors were like, well, how can we comply with this? This is greater than what we call Brady, so Brady versus Maryland. That's basically saying anything that's exculpatory or impeachment evidence has to be turned over to the defense. 3914 broadens that. It doesn't have to just be exculpatory or mitigating that's mandated to be turned over. It's essentially everything that was developed during the course of the investigation of the offense and then the subsequent testing by laboratories and things like that. So we were kind of going, how can we comply with this and make sure that we don't put all of our cases in jeopardy? And while that was happening, we started thinking, okay, we need to put a policy in place or practices in place. And then in 2015, when everybody was still trying to get used to the Michael Morton Act and how the mechanism works in practice in Texas, 2015 really, to me, sparked a huge change where we started paying attention to not just police and police conduct, we started paying attention to the forensic setting as well. Although we had been having those types of conversations, it was never the same way as what we thought about when we were thinking about police officers, right? For us, that was kind of the main thing that we needed to make sure that police always made disclosures to us and that kind of stuff. We never really thought about scientists in that way. And I remember 2015 because for me, so my youngest son was born in 2015 at the beginning of the year. So I go out on maternity leave. And while I'm out on maternity leave, I get this letter basically talking about the DNA mixture interpretation issue. And I know heads are rolling right now. It's like, oh, eyes are rolling. And so not just the DNA mixture interpretation issue, but also the recalculation issue with the statistics that had to be looked at to make sure that it was properly calculated. And so that comes through while I'm out on maternity leave. But so I'm going, okay, how are we gonna deal with this? So I come back and it's like a whole different world. It was like, I closed the door on one world and I just opened the door into a different one. That marks something in my memory because when I came back, Texas was like on a roller coaster ride, as was the rest of the country, really, when it came down to the DNA mixture issue. But that's when also the junk science statute that I was talking about earlier was revised, and it was basically broadened a little bit to include the ability to grant relief to somebody when the field of scientific knowledge is different than it was at the time of the original presentation at trial, or the testifying expert's scientific knowledge has evolved since the time they originally testified, or the scientific method that was relied upon at the time when the science was tested, or when the evidence was tested at that time, has evolved. So it broadened the scope a little bit of 11073. So we had that change in our legislature. We had the DNA mixture interpretation issue, and then we had the Tim Cole Commission that was established to look at the different things that to kind of make an analysis of what was going wrong in these cases that were being overturned, what had gone wrong, like kind of a root cause analysis type situation, and to try to figure out through this commission, how can we change the practice or the law in Texas to help prevent these wrongful convictions from happening in the future. So this was Texas's kind of beginning of the solution statewide to try to figure out how can we change these practices. Tim Cole, the commission was named after Tim Cole, who was posthumously pardoned after it was shown that he did not commit the rape that he was convicted of. Unfortunately, he passed away in prison before he was able to see his exoneration go through. Then I'll go into 2016 and then leave at 2018 for Judge Hervey. 2016, at that time, the Texas Forensic Science Commission became very active in looking at hair microscopy cases and bite mark cases. And at that time, also the PCAST report had come out, as y'all know, and the Tim Cole Commission came out with recommendations on how to change practices in Texas. Amongst those recommendations were drug field tests, making sure that those are dealt with in a certain manner, as well as recommendations on changing eyewitness procedures so that there won't be these kind of issues with biases or suggestions to the witness, right? So, you know, maybe a double-blind situation when you present photos to an eyewitness. So all this stuff was in turmoil and changing rapidly in Texas. Like I said, that was really the spark of everything, of this very rapid reform. In 2018, the Texas Court of Criminal Appeals, our highest criminal court, which Judge Hervey is on that court, came out with Ex parte Cheney. Cheney is a bite mark case out of Dallas County, so it was a conviction integrity unit case that I personally worked on. And the Cheney case involved challenging bite mark evidence, which hadn't really been done in Texas the way that we did it under 11073. So in Cheney, it was a gruesome double homicide case that happened in, I want to say it's 1987, definitely in the 80s. And our male victim had what was purported to be a bite mark on his forearm. So when the case came to us, you know, we were looking at it, and all of us were looking at that bite mark, and we're going, is that really a bite mark? What is that? That looks kind of weird. It's like, looks crusty. Who knows what that is? That doesn't even, you can't even see, you can't even like make out, you know, a dentition or whatever, any markings. And so we went back to the odontologist who had made the examination and testified at trial. And he had testified at trial that it was a 1 in a million chance that someone other than the defendant, Mr. Cheney, had left a bite mark on our victim's arm. 1 in a million chance. Of where did you come up with that statistic? And so we started asking questions. And of course, he ended up telling us, you know, I got caught up in the whole thing and, you know, I shouldn't have said it, but I said it, and I was wrong. So amongst those kind of scientific issues, right, so that we had a false evidence claim, we had an 11073 claim with the change in scientific evidence or scientific knowledge of bite marks. And we also had other claims in there as well, Brady violations and things like that, and of course, Mr. Cheney's actual innocence. So we thoroughly investigated this case, and we sent it up to the Court of Criminal Appeals for their decision. So let me give you a little bit of just an introduction to the way that we see things. In Texas, every state is different, okay? Every state in the country has a different way of set of laws, different way of doing things. In Texas, we have the high court for criminal cases, and the district attorney's office does not have the power to file a habeas petition on behalf of a defendant. We don't have the power to overturn a case on our own. We can't just go to our trial court and say, hey, this guy's wrongfully convicted, let's get him out of here. We can't do that. The case gets filed at the trial court level by the applicant, the defendant, and the state makes a response. And in the case, for example, of Mr. Cheney, we agreed to relief. We agreed that he was wrongfully convicted and he needed a new trial, and he was actually innocent. And the trial court listened to everything that we had to say. They made a recommendation to the High Court, to the Court of Criminal Appeals, and that recommendation goes up to the Court of Criminal Appeals. And that recommendation can either be followed or not. And Judge Hervey can give you a little bit more information about how that goes. But the cases can only get overturned in this situation if the High Court agrees with the recommendation. So we were fortunate enough. Judge Hervey wrote the excellent opinion for the Cheney case, and hopefully you can talk a little bit more about that, Judge. But it's an excellent opinion. I tell everybody in Texas, ex parte Cheney and ex parte Richard Miles, it's another Dallas exoneration whose opinion was written by Judge Hervey, are top of the line for criminal jurisprudence in Texas as far as actual innocence is concerned and other related issues. So if you ever want to look into how Texas does things, read those opinions. Very well written and great explanations on how the law is applied in those situations. So I will turn this over to Judge Hervey.
Thank you. I paid her a handsome sum. I did. And I don't mean this to be braggadocious, but I have to tell you something else about me so you understand why I'm so involved in all this. I was also on the National Commission for several years, and I'm a member of AAFS, and I'm on the senior advisor to C-Safe, and I'm an advisor to the police chiefs also. And I have a very close relationship not only with these people that we work well, we work together a lot, but also with the Texas Forensic Science Commission. Texas is odd. I get to say that because I'm not originally from Texas, and Texas has 2 Supreme Courts, one for civil cases and one for criminal, with equal jurisdiction, although they get invited to more parties on the civil side. What can I say? But in addition to my work as a judge, I also oversee a $30 million per biennium education grant to educate lawyers of all levels and prosecutors and defense attorneys. So in that capacity, we presently have 8 grantees. And because we furnish funds to them, we're often able to suggest certain training. So all of our grantees do train in areas involving forensic science. Do they train enough? No. But I will say we try, and we hammer, and we hammer, and we hammer. And we are presently involved in setting up a training with the Forensic Science Commission that will take a crime scene to writ on DNA. And it will be housed at the Capitol. We have about 350 seats, but it'll also be taped, and it can be sent throughout the Capitol. So if the legislature is actually at work, they could watch it if they're interested. And our legislature has done an awful lot, as Cynthia outlined, to move the needle forward with regard to the intersection of science and the law. My first interest in forensic science happened when I was still in law school. And I live in San Antonio, my court's in Austin, but we were crossing a bridge on the Riverwalk. My fiance, a friend of his from Atlanta who never visited us again because we were the victims of an aggravated robbery. And that evening, we had a show up. So we got to a police officer as soon as we were robbed. And we got the license plate, the car drove away, and they did a show up within, 10 or 15 minutes of the robbery. And the detective pressed us, he did talk to each of us individually, but he pressed us to ID all 3 people. Well, it was 10:30 at night. I could identify the gun and the guy that had the gun because it was 10 minutes later. But it was dark, and the other 2 were far away. And I said, I can't do that. That's ridiculous. So that situation bothered me going forward. So I was very interested in how certain things were done because of that. All right, so Moving forward, I also, as a prosecutor in the appellate section, I had the good fortune of having a capital murder case I worked on, and Fred Zane was involved. We also had brown hair testimony in that case. But there was a lot of other evidence. So yes, there was an error. We all knew it. And Fred Zane, but there was a lot of evidence, and he was convicted. He did not get the death penalty. So that was an interesting experience. But Texas, I don't know. You got the outline from Cynthia about how things progressed. As far as the court is concerned, the biggest part of our caseload is writs of habeas corpus. And unlike our civil counterpart, we have no discretion with regard to those cases. We have to take them. We do the direct appeals off death cases, and we have 14 intermediate courts of appeals in Texas, and we take about 7 to 10% of those every year. So we're quite busy. So when it comes to looking at this from where the court stands, we first really started getting involved in this with allegations of actual innocence. So, we get all this paperwork all the time, and people say, I didn't do it. So we thought, well, this is just another phrase to cover that situation. But there was this very, very great professor at the University of Texas, Professor Dawson, and we went over to talk to him and asked him, what are they talking about? He explained to us about actual innocence. They really didn't do it. Not, I was just the getaway driver, or, I was outside, or some other excuse. They didn't do it. He said, I'm a great believer in the criminal justice system in Texas. It works 99.9% of the time. But that extra percentage, you've got people in prison that are innocent. And y'all need to do something about it. So I can't even remember what year it was, but I was working with a very skilled defense attorney who incidentally was one of the original lawyers on the Michael Morton case. And between the two of us, we set up a conference at the University of Texas and invited everybody in the system that could fit, anybody that wanted to come, legislators, prosecutors, defense attorneys, whoever. And we put on the first conference regarding actual innocence. From there, I also worked with, we had a very, very aggressive senator from Houston. Houston had some issues. And Senator Ellis, every session, would introduce what he called the innocence packages. And there were things like asking for eyewitness reform, et cetera, et cetera, et cetera. He wasn't ever getting anywhere. But I started to look at what he was proposing, and then flipping back to when I got robbed in eyewitness ID, and I was very interested in his suggestions about reform and eyewitness identification. So I started working with Senator Ellis on some of these ideas. In the meantime, yes, we had the Dallas Integrity Unit established, but in 2008, the court set up what we called the Texas Criminal Justice Integrity Unit. I was the chair. We had 14 members. I picked people from across the spectrum for the criminal justice system, and I have learned that when you have a committee like that, two things are just absolutely important. One is you got to put people on that are really going to work, and no bomb throwers. You don't get anywhere with that. So we had all kinds of discussions, but to learn about forensic science, we did a couple of, I think, interesting things for the time. So I wanted to push this eyewitness ID reform. So I called Barry Scheck, and I said, will you come to Texas and present this concept to us? And when I say to us, we have a courtroom that holds about 75 people. So of course, everybody, we have about 75 employees for our court. All of our employees are there, and we ask the executive directors of all of the grantees to come for this presentation. That way, the executive directors could take this education back to their constituents. So this was going to be far-reaching. So my little joke about Barry, and I do have him on speed dial, I work with Barry quite often, was I called his staff, and I was born and raised 22 miles outside of New York. So I called his staff and I said, please tell Barry he cannot put on a New York performance in Texas. Texas doesn't like anybody else, but particularly New York, so, let's not. And they laughed, and they said, we got it. Barry came, didn't charge us a dime. All he wanted was a hotel room at the Driscoll Hotel for some reason. And the hotel tells us they had no rooms, but that's a lie. They always have a room. So Barry got a room. And he did his presentation, and of course it was excellent. And the most conservative judge on my court was sitting next to me in the audience, and she said, "Why? Oh my God, if this is all this is, we can get behind this movement." And we did. So I testified to the legislature, listening to everybody involved, except the Houston Police Department was not excited about the proposition. And they were all in the hall before I testified. None of them would speak to me. But anyway, we made that reform. We also had Gary Wells came and talked to us about eyewitness ID. We had Dr. Leo from California talk to us about false confessions. We had some arson experts. We had someone talk to us about evidence storage. And we also made some proposals to the legislature from this. The unit is in limbo right now because I have my grant job, and I'm also co-chair of the Judicial Commission on Mental Health. So I'm a little busy, and we haven't reconvened that unit in some time. What happens, another interesting thing is when you had the problem with the DNA mixture interpretations, we would get letters from prisoners. And whether it was that situation or another one involving forensic science, we can't be pen pals with the people in prison. That just doesn't work. But what the court does is it will send them a letter saying, we can't be of assistance to you in this matter, but you can contact one of the criminal justice integrity units in Texas, and perhaps they can be of service to you. So the court does do that. Cheney was a very interesting case to work on. Cynthia did a great job. It was interesting to push through conference, but the court does recognize the concept. And we have put down cases with, I know we learned about Billy the dog. Well, we had a dog case. We busted dog sniffs. We have a case on eyewitness identification. We have a case on arson now. So we are paying attention. And 11073 does allow for a broad spectrum of question science to be brought back to the high court. Now, we have an opinion that I'll be honest, I dissented to, which I think is odd when you look at all the cases nationwide. But this particular case says we can't put our science knowledge, into our discussions when we get direct appeals or appeals off the intermediate courts. That's all the science has to come in at trial. But the writ process is where we're most active with the science. And that's a great help to us and, of course, the people that are wrongfully convicted, because that's where we are doing the issue spotting and can make a difference. And Texas is very generous. These exonerees get $80,000 for every year they spend in prison. They get an annuity, they get free health care, they can get free education. Now, I wouldn't want to spend one day in prison, but we try to at least assist them in the future. And Richard Miles, who Cynthia referenced, Mr. Miles now has an organization where he helps other prisoners when they get out. He's amazing. So he uses his money for that. Michael Morton, who spent 25 years in prison for killing his wife, he didn't do it. They did find the real person. He also uses his money to help other people. So that's amazing. And we often have exonerees come in and speak. And I'm amazed at how many times I've spoken to exonerees and they're not angry. I'd be a little pissed off. But anyway, they're very helpful to the whole system. Texas is different. We're not trying to brag. We just hope that everybody understands. I know that I was a little concerned that people thought the state actors were not doing as much as the feds, but I don't see it that way. And perhaps it's because I'm from Texas, but I know Arizona is doing a lot of stuff. A lot of states are moving forward. We're just fortunate that we have so many good people that are interested in the project, and we will continue to keep going. So thank you very much for listening to us.
I've seen people do this. Okay, Joel says we do have time for questions. All right, I will ask one while you guys think about it, but you were given a lot here. One question I have mainly, Peter, is for you, but I think everybody can comment on this. I like to say Texas has gone from zero to hero, in terms of forensic science. I know you don't like that, Judge, but from outsiders, we see this, and we do see Texas as a role model, especially where I am in Tennessee, where we have essentially zero of this reform, right? But my question is really about the lab, and one thing that you didn't mention, but I think is important, is the independence of the lab from the police, correct?
Yeah, so again, I can kill the rest of the afternoon talking about how this evolved, but yeah, HFSC is weird. My quip in this is I work with the chief of police, I work with the district attorney, I work with the mayor. I am quite certain I piss all three of them off regularly, but I don't work for any of them. I actually work for a board of directors, because at that junction of about 2012, and it really was HPD's idea. Matt Slinkard, who just recently retired from HPD, was executive chief, was the one that crafted the idea of pay attention to the NAS report. Let's take the lab out of HPD and stick it into what's called a local government corporation. That's why my title is president and CEO and not director. I'm still an element of city government. We've got a .gov email address, but it is a separate fiduciary entity from the city of Houston. So my boss is a 9-member board of directors, one of whom is an exoneree. Anna Vasquez is the exoneree that's on our board right now. She was one of the San Antonio Four. She served 15 years for a sexual assault that not only did she not do, it just didn't occur at all. Anthony Graves was the exoneree that was on before that. He served, I think, 18 years for a horrible multiple homicide that he didn't commit. He had 2 separate execution dates set for him and was ultimately exonerated. So one of my bosses is an exoneree. It's a very different way of running the laboratory. And yes, there is a lot of tension in this. We've navigated through it, but you can see right now some of that tension is rising again, of this push and pull of the laboratory as a separate counterbalance in the criminal justice system. And I found myself over the years talking about this less about the independence, because I find that's a term that gets weaponized a lot, and rather, how do you put the laboratory at a better level of parity with the other components of the criminal justice system? You can think about it that we desperately need law enforcement to be law enforcement. You want law enforcement to have a pretty low tolerance for false negative and a pretty high tolerance of false positive. You want them to go arrest a bunch of people and prevent public safety compromises, but the rest of the system has to be able to counterbalance that. And I argue the laboratory is the primary counterbalance to that, because labs are designed around being exquisitely sensitive to false positive, and we've got a pretty high tolerance for false negative. So it's almost like the flip of law enforcement, but it has to be put in the system at a level whereas it makes no sense for law enforcement to report to me, it makes no sense for me to report to law enforcement, because we serve different purposes.
Very good. Ma'am, question?
Hi, yes, my name is Christina Reed, and I'm a science writer and editor with NIST. So I helped co-author the bite marks report that came out last year. And thank you. And I have 2 questions, one for Judge Hervey and one for Peter Stout. And the first for Judge Hervey was on the commission's ruling on preventing bite marks from even coming in as evidence. I found when I was researching this report, surprising that other states haven't followed suit. And I was just wondering, even like Florida, for example, which is now going through all their bite mark cases, you can still present the evidence if you have it. Like, they haven't ruled it out as something they just won't see. So I'm just wondering, like, how can America move forward when it's such a fragmented way of going about doing all these different individual rules on that level? And then for Peter Stout, Dr. Stout, how much does AI help you with capacity? Is that something that you've looked into? Is that something that labs can use? Thank you.
Yeah.
All we can do is share and keep training. We can't dictate to other states, but hopefully when they see reports like you've written, or at big meetings, we'll share this information and it'll spread. That's all I can hope for as far as case law is concerned.
I think I would point out one thing in Texas. There is a remarkable group of individuals in Texas that have moved this forward. You got two of them sitting right here. Rodney Ellis, who's now a county commissioner in Harris County, Lynn Garcia, who's general counsel for TFSC. I mean, there are this group of individuals, and it is a small group of people. And, the old, I think it was Maya Angelou, the only thing that actually makes a difference in the world is a small group of dedicated people. That's what we got in Texas. And, they're a group that I don't think necessarily get as much recognition of the remarkable tenacity and remarkable just commitment that this group of people has had to make this stuff happen. Hopefully the example there can help other states and empower those small groups of people elsewhere to do the same thing. AI, oh boy, yeah, it's going to be a wild ride. In my mind, the place I think AI has a real utility to laboratories right now is in what I refer to as retrospective document audits. Laboratories always, now I probably get the lion's share of Chapter 64 post-conviction kind of testing. We kind of have the lion's share of death penalty cases in Houston anyways. That's just the nature of what we are. But labs always have the circumstance where we have run up on some issue, mixture interpretation, and now I've got to audit back through decades of records that are not all very pretty. It's a dirty data set. AI tools to help automate and better carve through retrospective records, even if it's nothing more than natural language heuristics and handwriting, it's an immense help. My quality group, it is always thousands and thousands and thousands of records that we are constantly auditing back through. That is something, because that's resources that I have to put there that then I don't have to do something else, because it's a zero-sum game in labs. I spend $1 on a record audit, that's $1 I don't have for a sexual assault kit. So if we can expand and improve that, and I've talked a lot with Microsoft, and if anybody from Microsoft is listening, hey guys, pay attention to me. Because I think there's some really useful tools there, but man, trying to get it there and make it happen, I could use help with that.
Next question.
Yeah, hi, my name's Elise Walsh. I'm a newly minted geneticist from Johns Hopkins. So I've been following a lot.
You want a job?
I was just going to say.
Yes, actually I am in the market for a job right now. But I digress. So I've been following a lot of the developments in terms of genetic genealogy, especially Texas's own Othram. And I was wondering what, y'all are doing in terms of use of genetic genealogy, especially in terms of perpetrators, not just unidentified victims.
Y'all looking at me like I know something here, geez. Yeah, it's going to be a wild ride. And we're just at the start of this one. And I think, trying to put on my prognosticator cap on here, I think you're going to see this wild ride is going to really have a focus in Texas because of the overlay of Texas Forensic Science Commission. We are a state that has a requirement, a legislative requirement for the laboratory to be accredited. and personnel who are doing this to be licensed. It's actually really rare in the US. I'm seeing that it's not the people that get this, but you get, okay, not my hairdresser, but y'all's hairdressers have more requirements in this country for licensure and accreditation than forensic scientists do in this country. It's a rare thing of states that actually have accreditation and licensure. So that overlay is gonna, I think, cause there to be quite the fight in Texas around this, because you've got companies that are resistant to accreditation and licensure, companies that are willing to deal with that. And I mean, you already saw Rapid DNA. You Google me and Rapid. You see I've spent some time on opposite sides from a particular company out there. You know, and again, it was because basically of a licensure and accreditation thing. So I'm not sure I answered your question, but yeah, stay tuned. It's going to get interesting.
Joel, we have a question from one of our virtual colleagues.
We do. This is primarily for Judge Hervey, but anyone can answer. Most forensic scientists work in crime labs, not post-conviction labs. The Texas training on crime scene to habeas rights sounds promising. How can forensic scientists and forensic science service providers learn more about their role and become more involved in post-conviction testing, or is this all performed through private labs?
Actually, most of the post-conviction testing happens, at least in my experience in Texas, most of the post-conviction testing happens in the public labs. We do an immense amount of that. Like I say, in Texas, I would venture, I've probably got the lion's share of death penalty cases, and then I've also got the lion's share of post-conviction testing that flows through us because that's where those cases were.
So as far as Dallas County is concerned, we do both, you know, we go with private labs and with our county lab. So we don't, you know, particularly have a lot of constraints when we're looking at our cases. But I will say that when, and I forgot to say this earlier, and Dr. Stout, you may have some opinions on this too, but when we started, you know, having more conversations with laboratories and asking for more information, a lot of times we were getting kind of looked at funny. And it wasn't just us in Dallas, it was our other, you know, DA's offices also asking questions about disclosures, about making sure that we have information about analysts, you know, maybe proficiency test issues or anything like that that happened, or corrective actions or anything that happened during the, you know, during the course of them being a part of the laboratory. And so, although this doesn't go to the question, I did want to make sure that I mentioned this, and Dr. Stout, if you have any other opinion on it, the way that they do it in Harris County, but we like to have conversations with laboratories, and so a lot of times it is these kinds of, you know, questions that we ask that we, you know, get questioned about, especially from private labs, saying, why do you want to know that information? It's like, well, because in Texas we have laws that require us to make disclosures. We do require analysts to be licensed by the Forensic Science Commission before they can perform any testing in a Texas case. The lab itself has to be accredited by the Forensic Science Commission, as well as the, you know, obviously national accrediting body. And you know, we have had a lot of these conversations with our public labs, but the private labs sometimes don't understand why we ask these questions. But when they do testing for conviction integrity cases, we always tell them, hey, you know, there are specific rules and policies that we have to comply with, so we want to make sure that they understand as well. And that goes for any laboratory, but specifically for private labs that aren't necessarily used to prosecutors asking these kind of questions.
Yeah, I would say, and this is going to go to the question about FGG as well, and I've worked in commercial laboratories, and I get the philosophy around that of the competitive advantage and proprietary information and the desire to want to withhold that stuff. But if you're going to do business in Texas, it just ain't a thing for you. And it's going to be an issue for FGG of those companies that want to think they've got something proprietary that somehow they can magically withhold that just ain't going to hold water in Texas. And Me personally, I think that's a good thing. Some of the worst behavior I've ever seen in laboratories has been in commercial labs.
Okay, so we have one more question at the mic, and then if anybody has any other questions, I'm sure the panel will be happy to discuss at breaks and lunches and things like that.
Great, thanks. Good morning. My name is Sarah Hansen. I'm an AUSA at the U.S. Attorney's Office here in the district. So it's obviously the nightmare of any prosecutor to have a case to wrongfully convict somebody because of the use of junk science, but we sort of come to this at a little bit of a competency disadvantage because we are not scientists. So what advice would you give for it when a case comes across your desk and it has a scientific component to it that you're not personally super familiar with or haven't worked with before? Like, it's not DNA, something you see commonly. How can we be sort of smarter consumers about that and ask the right questions to make sure that we're not propagating something that's could help our case but maybe shouldn't be used because it's not reliable?
So I always tell people when I train prosecutors, you need to ask questions. A lot of prosecutors, believe it or not, don't ask questions because they're like, well, that's kind of, that's your wheelhouse. I trust that you're, telling me the right thing, all that stuff. And, they just ask the basic questions to be able to present whatever it is to the jury. And that's really the wrong approach. I mean, you really need to ask questions as if, I say, kind of use the elementary approach. I'm a fifth grader. You need to explain to me what this is, what it is that you're talking about. Explain it all to me, the process. Go through your litigation packet. Make sure you understand everything that's in there, the good and the bad, if there is anything that you need to explain. And also, if there's something that you're not familiar with, then do some research on your own. I mean, just do a Google search. You can find, a lot of times you'll find things where it'll be very helpful. There's already something published or a case law or something out there that helps kind of break things down. Oftentimes it's going to be scientific articles or other kind of articles that have been published to help explain it in a more, to a layperson. But never stop asking questions, because it's when you stop asking questions that things go horribly wrong. And I think a lot of times it's the presentation, the lack of understanding of what this science is telling you to the application of the facts and the way that that's presented to the jury. A lot of times that's where the error is, because people don't know how to explain it. And so it gets a little bit complicated. And I'll tell you, one of the things that's complicated now for people to understand, at least in Texas, we're starting to, train more about it, is likelihood ratios in DNA. It's not like how we used to explain things in like the number of Earths. It's not like that anymore. And so now it's like, okay, what am I supposed to say and how do I say it? Because if you say it this way, it's wrong, and you say it this way, it's right. And wrapping your mind around something like that, especially if you've been in practice for a while and that's what you're used to the other way, you have to retrain your brain. But most of all, it's asking questions and being curious about things.
From the lab perspective, I think most responsible laboratories wish lawyers asked more questions. So if you are asking questions, help me understand, I really don't quite get all that, and they get impatient with you, warning. And if you get the Ipsy-Dixit arguments, it is because I said it is, warning, that one's, you got a problem there. But I mean, any responsible laboratory, I think by and large, they're really interested in helping you understand, explaining. They want to, and they wish people would ask more questions.
One other thing that I'll suggest, I don't know where you went, so, oh, there you are, is go to an expert in that field that's independent of the case. Find somebody who's board certified in that field and have them review the case for you. Any expert should be able to review and say, yes, this is right, or yes, this is overstated, and give you some warning signs as well. Even if they're not in a laboratory, let's say it's, an academic lab that did it or something like that. Like Dr. Stout said, anybody in the field should be able to answer questions for you. So, but go to somebody that isn't necessarily that person. Okay, we have one more. Are we done?
I just want to make a
One
quick
quick?
comment. I'm Charlotte Ward. I'm a private expert in forensic science. I think the key question that needs to be asked is, what are the limitations of this test? The attorneys are so focused on, how do I get this in the court? They don't ask, well, what are the problems with this? What does it not say? And I think that's the really key question in any test.
Thank you very much, everybody. We'll take a, how much?